Good afternoon, everyone, and welcome to this flash webinar on the important judgment of the Belgian Supreme Court, which has a major impact on the mandatory Belgian protective law on international exclusive distribution agreements. My name is Willems, and on behalf of the entire commercial litigation department, welcome to this flash webinar, which will last approximately 20 to 25 minutes. Before we start, some practical information. If everything goes right, you can see the presentation now on your screen, and this presentation can now also be downloaded on the right-hand side under the handouts page. We will also, of course, give you a certificate if you last until the end the webinar, and then you will receive a certificate from GoToWebinar. Also, there's a flash webinar, so you can also ask every question that you would have using the chat function, and you will also receive by email then an answer to your questions, which will be dealt with then in writing after the webinar. So all your questions can be asked during the chat function or sending an email to me, and then we will provide you with an answer by email. Why did we decide to give a flash webinar on the 22nd of June before the summer holidays is because this is a very important judgment rendered by the Belgian Supreme Court, and it's rarely that a Supreme Court judgment, Court of Cassation, is so disruptive in a certain sector as this judgment rendered on the 7th of April 2023 was for the distribution sector. Why was it so important? Because in a judgment, the Belgian Supreme Court ruled for the first time that the Belgian protective law is no longer an overriding mandatory provision. I will also elaborate on that further on in the sense of the Rome I regulation. And this has, of course, important consequences for the possibility to refer or to apply arbitration to an international exclusive distribution agreements, and also implicitly that the Belgian courts, also arbitration, but also the Belgian courts would no longer be obliged to apply Belgian law on exclusive distribution agreements, at least the mandatory part with regard to the termination. The topics that I will discuss are the possibility of arbitration and also the validity and the effectiveness of choice of law clauses, but also choice of court clauses. And both topics, I will focus on that after and before the judgment, taking into account the judgment rendered on the 7th of April. So what's the overview of this flash webinar, which will last, like I said, 20 to 25 minutes only, is to set out first the legal framework, then also the nature of this legal framework, the mandatory protective law character of the Belgian law, but also that there is three exceptions to that. The first is the choice of court clauses, the choice of law clauses, and which is also straightforward exceptions. Third one are the arbitration clause, and this goes into the heart of this webinar, as there the Belgian Supreme Court has rendered a decision about arbitration clauses and the choice for foreign law. And then last but not least, I will focus, of course, on the major impact of this Supreme Court decision for the distribution sector and, of course, for the international distribution agreements, what will be the consequences thereof. Before we start, of course, setting out first the legal framework, we are now discussing the Belgian specific legislation which applies to exclusive distribution agreements and which is laid down in article of book 10, article 35 to book 1040 of our Code of Economic Law. And it's important to note that this specific legislation, which applies to exclusive distribution agreements, only has a limited scope. So it only applies to the termination of exclusive distribution agreements concluded for an indefinite period of time. You see three words indicated in italics in the slides, and they are, of course, of utmost importance because they are the conditions for the application of this legislation. First, it's limited to the termination, so contractual right, negotiations, pre-contractual duties, and so on are not governed by this specific legislation. It only relates to the termination. So minimum purchase obligations are not under not fall in the scope of this specific legislation. Secondly, it should also relate to exclusive distribution agreements. It can also relate to exclusive distribution agreements which are almost exclusive, where the seller or distributor has almost the exclusive right to sell a particular product in a specific territory. And it can also relate to, should also relate to distribution agreements concluded for an indefinite period of time. It also governs the distribution agreements concluded for a definite fixed period of time, because after 2 renewals, they're also deemed to have existed for indefinite period of time. So it only relates to these 3 conditions, and then the specific legislation will apply. Now, what is in the specific legislation? What's the content, why it's so important, and it's mostly protective for the distributor? It's so important because it provides for a reasonable notice period or a compensatory indemnity in case of termination by either party, except in case of gross faults. The purpose of the reasonable notice period is, of course, in general, to give the distributor the chance to acquire a new source of income, also to organize or reorganize its activities, and also to fulfill its commitments towards third parties. The duration of the notice period, it should be reasonable, but what's reasonable, of course, this is determined by case law, and what's usually taken into account is, of course, the territory, the size of the territory, the duration of the distribution agreement. There will be a difference between a distribution agreement which only lasted for 10 years or which lasted for 40 years, and where the distributor started from scratch, so without any clients already at his disposal. Also, the share of the products in the total sales of the distributor, and any investments made by the distributor. On top of the reasonable notice period, there can be also when the notice period was too short, or when there was no notice period, that can also be the case. Then a compensatory indemnity can also be should be awarded by the principal to the distributor. And this is usually calculated over a reference period of 3 years, and it's usually based on the turnover of the gross profit, but this is also determined by case law. So there's no legal provision in the specific legislation which stipulates very clearly, like there is for commercial agency in Belgian law, but there's no for exclusive distribution agreement, what the amount should be. This should be determined by the court on a case-by-case basis. Next to the reasonable notice period, or in the absence thereof, the compensatory indemnity, the distributor also has, under the specific legislation, a right to an equitable additional indemnity, and this usually applies to the goodwill indemnity. And the goodwill indemnity is the additional compensation which is due by the principal to the distributor if the clients remain with the principal after the termination of the exclusive distribution agreement. There are certain conditions in order to be entitled to the additional indemnity that have to be fulfilled by the distributor. And one, of course, he has to prove that there is already an added value for the principal, and that he created this added value, and it was not created only by investment, for instance, advertisement project or investments by the principal itself or the brand, that this created the increase of clients. This can be also due. There can also be another compensation for investments or a redundancy payment, and this is then also which the distributor have to pay to his employees due to the termination of the distribution agreement. So these are 2 important possible indemnities which can be due by the principal to the distributor pursuant to the Belgian specific legislation, and which cannot be avoided by the principal. The reason that cannot be avoided is because of the nature of the specific legislation, which is of mandatory law, and the application cannot be excluded, or the parties cannot contractually derogate from it. There's an important exception, and the exception is that the parties, after the dispute has arisen, can of course agree by common agreement about the specific indemnities, about the notice period. There can be then a settlement. But before, for instance, in an agreement, the parties cannot stipulate that the notice period should be 6 months or 12 months. This contractual provision will be invalid, and the distributor can still claim damages or argue that the notice period was too short. What's important to mandatory law, where it's laid down, is in Article 39 of Book 10, and there it states literally that the distributor may, upon termination of distribution agreement, that was the first condition, with effect for all or part of the Belgian territory, that's a second also condition, it should relate to the Belgian territory and at least to the Belgian territory. Also there, the Belgian Supreme Court already rendered in 2008 or 2010 a landmark judgment that the specific Belgian legislation will only relate to the part of the distribution which is executed in Belgium. And it allows then the distributor to summon the principal in Belgium, either before the court of its own domicile, which usually will happen. The distributor is based in Belgium and will then also issue proceedings against the principal in Belgium, or before the court of the principal domicile or registered office. In case the dispute is brought before a Belgian court, it will exclusively apply Belgian law. So this means mandatory nature. Belgian courts have competence in case of termination of exclusive distribution agreements, and the distributor and the Belgian courts will also apply Belgian law when the distribution agreement has effect on the Belgian territory. Now, there are also exceptions, of course, to these provisions, and the first one is choice of court clauses, which would have as a result that the Belgian courts would not have jurisdiction, and the parties can, of course, choose the competent court for disputes relating to their international agreement, what usually also happens in international context. There we have the Brussels I regulation on competent court and execution of judgment, Article 25, which lays down the principle that the parties can refer jurisdiction to another court or a court that they have together chosen. Outside the EU, there we have to look at the relevant treaties where two parties or multiple parties have been involved in order to see whether there's also an agreement about the choice of court and whether it's valid or not. But you see already that this choice for a competent court outside Belgium, that it's not compatible with the mandatory right for the distributor to summon the principal before the Belgian courts. And there, this discussion has already been settled, that the European Court has confirmed the priority of the EU law over national law, and also specifically in the context of exclusive distribution agreements, we refer to the Corman-Collins decision of 2013. But even before, there was already case law which confirmed in specific cases that we have handled already for German principal against a Belgian distributor, where the Belgian courts have rejected their jurisdiction and also stated that in accordance with choice of jurisdiction clause in favor of the German courts, that they could not handle the case. So the Brussels I regulation has priority over the quoted Article 39 of Book 10. And so the Belgian courts must respect the choice of court clause in favor of foreign EU based on the Brussels I regulation or other treaties, but this will relate then to foreign jurisdiction. So this is a first exception to the fact that the Belgian courts would deal with the specific legislation on exclusive distribution agreements. A second exception is the choice of law clauses. Of course, in the Rome I regulation, Article 3, lays down the principle that the parties can choose the applicable law to their international agreements. Outside the EU, the same as with choice of court clauses, we have to look at the relevant international private law of the court seized. Here we have also another problem, there we have Article 9.2 and 9.3 of the Rome I regulation, which states that there can be an application of national provisions of the competent court which protect the public interest. And this is very important also for the Supreme Court decision, that these cannot be excluded. And these are so-called overriding mandatory provisions, which are usually applied on by the court who deals with the case, and it will then usually apply its own specific mandatory legislation. And what has been accepted or implicitly accepted is that the Belgian law, the Belgian specific protective law on exclusive distribution agreements with regard to determination, is a so-called overriding mandatory provision in the sense of the Rome I regulation, the articles 9.2 and 9.3. So the conclusion of a choice of law clause where the Belgian courts are confronted with choice of law in favor, for instance, of German law, is that the Belgian courts will nevertheless apply mandatory Belgian law on exclusive distribution agreements regardless of the choice of foreign law. I will come back to this when we discuss the Supreme Court decision, because this can also be changed further to this decision. We have a few examples. A German party principal and a Belgian party distributor to an exclusive distribution agreement have chosen to apply German law and to refer jurisdiction to the Belgian courts. Then the Belgian courts could still apply Belgian mandatory law on exclusive distribution agreements on the basis of Article 9.2 of the Rome I regulation. Also, in the same example, when they would decide to apply Belgian law and make the German courts competent, even if they would decide to apply German law, then the German courts could still apply Belgian mandatory law on exclusive distribution agreement because it's linked to the place where the distribution agreement or the obligation should be performed. Although we know from practice, when we give advice, we know that the foreign courts are very reluctant, and we have not yet experienced that they would apply then the Belgian mandatory provision on exclusive distribution agreements. The third exception, and this is the most relevant for the flash webinar of today, is also with regard to arbitration clauses. Why is this an exception? Because usually the Belgian courts, you may recall the quote of Article 39, have jurisdiction to deal with the termination of exclusive distribution agreements. Arbitration is, of course, an alternative for the Belgian courts, and the parties, certainly in an international context, can choose to refer disputes to an arbitration forum, which can be based in New York, in Vienna, or in another state outside Belgium. The principle of arbitration has been laid down in the New York Treaty, and of course, national courts, the national Belgian courts, should in principle reject their competence in favor of arbitration, because Belgium is also party to the New York Treaty. There was a discussion before 2013 about the fact whether exclusive distribution agreements could also be settled by arbitration, but this has been settled. The issue that still remains was an arbitration clause, not with a choice for Belgian law, but with a choice for foreign law, because this would mean that by the arbitration clause, including the choice for foreign law, that the application of the mandatory Belgian law and exclusive distribution agreements could be contractually circumvented. And the same reasoning goes as on the previous slide with regard to the choice of law clause. This would be incompatible with Article 9.2 and 9.3 of the Rome I regulation, which stipulates that overriding mandatory provisions cannot be excluded. So what was the situation? That arbitration was accepted, but only on the condition that Belgian law would apply, and not if that would lead to the application of foreign law by the arbitration forum. We will see now that the Belgian Supreme Court has also rendered the judgment specifically with regard to this situation. So what were the facts of the case of the Supreme Court decision of the 7th of April? It was an Austrian principal and Belgian distributor, international context, exclusive distribution agreement for the distribution of glass packaging in the Belgian territory. So it was on the Belgian territory, and at first sight, all conditions for the application of the specific legislation were fulfilled. In March 2018, already the principle terminate distribution agreement with immediate effect, and the principle, the distribution agreement, that's important, was governed by Austrian law and contained an arbitration clause. So there would be an arbitral tribunal, and the place of arbitration shall be Vienna. I assume also that the language, the choice of the language of the proceedings would be English. Nevertheless, the Belgian distributor relies heavily on Article Book 10, Article 39, and decides to summon the Austrian principal before the Belgian courts in order to claim a compensatory indemnity and also the equitable additional indemnity, such as the goodwill indemnity. Procedural elements in this case, which are also interesting, is that the Austrian principal, of course, claims that the Belgian court is not competent and that the case should be referred to arbitration, which means that the Belgian courts could not deal with the case and should reject the claim of the distributor, because this was agreed between the parties in the distribution agreement. The Belgian Court of First Instance rejects the arbitration and states that it can deal with the case based on the mandatory nature of the Belgian exclusive distribution law as so-called overriding provision. So confirms what has been laid down in the previous slides on the choice of law clauses. Then the case has been dealt with by the Court of Appeal, and there the Court of Appeal states that the case should be referred to arbitration because while Belgian mandatory law should indeed be applied, and this is interesting, Austrian law provides a similar level of protection to the distributor. While this is a consideration which is often used in commercial agency, it's not so often used in exclusive distribution agreements. And then the case has been appealed to the Belgian Supreme Court, Court of Cassation, and they have rendered on the 7th of April a new decision, which finally decides on the reasoning and grounds of accepting arbitration in disputes related to exclusive distribution agreements with the choice of foreign law. And what's now the ruling of the Belgian Supreme Court? They have not looked at a similar protection, but they have decided that the articles 35 to 40, including the important article 39, that they essentially protect not public interests, which is a condition for the application of so-called overriding provision, that they essentially protect private interests and are therefore not overriding mandatory provisions within the meaning of Article 9.1 Rome 1 regulation. So this means that disputes concerning termination of exclusive distribution agreements, that they now can be referred to arbitration by the Belgian courts, or the Belgian courts cannot deal with them, even if there is a choice for foreign law that would have as a consequence that Belgian mandatory law with regard to the termination of exclusive distribution agreements could not be applied. And in other words, and I will come back to that, that the Belgian courts, not only arbitration, are no longer obliged to apply mandatory Belgian exclusive distribution law on the basis of the Rome 1 regulation, and in doing so can also accept arbitration with a choice for foreign law, which is something which is which is new and which also gives opportunities, of course, in contract negotiation in an international context where the principle is based outside Belgium and can now also rely on a clause, an arbitration clause with the choice of foreign law, which was not the case before. So the major impact of this decision, judgment rendered by the Belgian Supreme Court is threefold. First is now for conditionally of, I think, for 99% sure that exclusive distribution disputes can be unconditionally referred to arbitration. And that was already something which was true, but that the parties are also free to choose the applicable law. They are not bound by the fact that arbitration is conditional upon the choice for Belgian law. They can also now choose a foreign law. Of course, the advantage of arbitration is, you have the choice of the arbitration rules, ICC, in Belgium, CPINA, also the choice of the arbitrators, which may be more specialized arbitrators than when you appear in a certain chamber before the court, which may have less experience or be less aware of all the case law. An important advantage is the language, and fast and efficient, and of course recovery of legal fees, where arbitration can in principle guarantee a full recovery of legal fees, while you know that before the Belgian courts we have the judicial indemnity, which is a fixed fee. Of course, there's also disadvantage of arbitration, which we all know, is that it can be costly. And to start the proceedings, sometimes there are more procedural steps which have to be taken, while writ of summons is more straightforward. But to give you an example of the impact thereof is that an exclusive distribution agreement between an Italian principal and a Belgian distributor with a choice for arbitration in Belgium or in Italy, and with the law of arbitration being Italian law, is now valid as of the decision of the Belgian Supreme Court. A second major impact consequence is that this has increased legal certainty and gives, of course, more importance for contract negotiations in the distribution context. Because the parties will now, certainly after this decision of the Belgian Supreme Court, more stress, certainly the principle, I assume, on the fact that the parties can agree already on arbitration and on the applicable law, while the distributor cannot rely anymore on the mandatory provisions, and it creates legal certainty, but it will also give pressure on contract negotiations between a distributor and a principal, because the distributor knows now that he or she will give up its rights when he signs an agreement with the application of foreign law, which may provide not for the same protection as the Belgian, which is quite exceptional, specific legislation will do. However, and this is still theoretical, it's still possible, of course, that the arbitrators, although it would be a little bit absurd because of the decision of the Belgian Supreme Court, they can now act and apply foreign law, that they would be of the idea that they will also have to apply mandatory Belgian law. I don't think that this will happen, and that they will just apply the foreign law. A third important consequence is the potential impact outside of the arbitration context. And of course, this judgment has been rendered within an arbitration context, but the question will also be, what will the Belgian courts will do when there's a freedom of choice of law, when there's a clause referring that the parties choose for an applicable law which is not Belgian law, and when the case will be dealt with before the Belgian courts. Based on the paragraph in the judgment, and this is also quoted, you could deduct from the judgment that the Belgian law on exclusive distribution agreements in general could be dismissed as an overriding mandatory provision. And this would also mean that not only the arbitration courts, but also in the decision to refer a case to arbitration, but also when a court will be confronted with a case where they have jurisdiction, but where the application is foreign law, that they do no longer mandatorily need to apply Belgian law, and that the parties are completely free to choose the applicable law. This would also have a major impact, of course, on the current situation, which is not the case. Even if there would be a choice for foreign law before the Belgian courts, then the Belgian courts could still, or the distributor could rely on the fact that the Belgian courts would apply Belgian mandatory law. This will, most likely, will change after the judgment of the 7th of April of this year. It goes even further, and this is my last slide, that it could have potential impact outside the arbitration context, but also outside the termination of the exclusive distribution agreement, because the fact that this specific legislation on the termination of international exclusive distribution agreements, that this is not considered as an overriding mandatory provision, could also be that, for instance, other acts, Belgian acts like the B2B Act, which do not relate specifically to the termination of distribution agreements, but to contractual rights like unilateral price changes, minimum purchase obligations, that this could also be considered as not constituting an overriding mandatory provision, and that also Belgian or other courts based in the EU or wherever they may be based will no longer mandatorily have to qualify these clauses as forbidden, because the B2B Act will not apply and that solely foreign law will apply. This could, of course, lead to imbalance in contract negotiations, and it's a big question whether also this decision of the Belgian Supreme Court will have an impact on other Belgian mandatory or so-called assumed mandatory legislation, but this is something that we will closely follow up within the next months and see whether there will also be new case law by the Courts of Appeal or by the Belgian Supreme Court. Like I said before, and I promised that I would keep it short, but it's already 2:30. Any question that you will have, you can ask them via the chat function or send me directly an email, and I will be happy to answer them. On behalf of my colleagues at Lydian, and I want to thank in particular Jonathan van der Stichelen, Arthur van Lanker for the preparation of this webinar. And on behalf of all my colleagues of our commercial litigation department, I wish you pleasant summer holidays, and I hope to see you soon in September for another webinar. Thank you.